Well, hello again, and welcome to our Ask the Experts live webinar series. Today's presentation goes beyond the 504 plan, problem-solving challenges throughout K-12 and college. My name is Chris Rich. I am the CEO and Executive Director of the National Celiac Association. Back to school is right around the corner, and so we want to thank you for putting some time into your busy day to be part of this important conversation. The National Celiac Association, our mission is to educate, advocate, and empower for individuals, families, and communities affected by celiac disease and non-celiac related conditions. This includes a wide array of initiatives focused on specific demographic groups, and that includes our Raising Our Celiac Kids program, or ROC, which directly assists kids and their families, and also supporting our celiac seniors, which addresses issues faced by our elderly population. You can find more information about NCA and our initiatives by visiting our website at nationalceliac.org. Let me just move my screen. There we go. The National Celiac Association's Ask the Experts live webinar is an educational series that provides an intimate and casual environment with some of the top professionals in their field of expertise. This series is a complementary piece to the Ask the Experts Q&A section of our website at nationalceliac.org/Q&A. If a question you have does not get addressed during this discussion, please go to that Q&A page, which has hundreds of topics and questions related to celiac disease and non-celiac related conditions. A couple of other housekeeping items before we get going with our distinguished speakers today. You're welcome to ask general questions through the Q&A feature, which is located at the bottom right corner or in your toolbar. Just go in there and put a question in. The chat will be disabled for this presentation. We appreciate all the questions that we've received from our registered attendees prior to today, and we'll be addressing many of these as we go through the session this afternoon. Closed caption is also available by clicking on the CC button on the lower portion of your screen. Please note this is an educational webinar, and no information is intended for diagnosis or treatment of any medical condition. Please seek the advice of your physician or another qualified health provider with any questions you may have regarding your personal health. All of our Ask the Expert live webinars are recorded and available on both our website and also our YouTube channel. The site address again is nationalceliac.org, and we're found on YouTube by searching National Celiac Association. You'll also be receiving an email from NCA that will have the link to the recording of this webinar included in that. You can look for that email to hit your inbox sometime in the next couple of weeks. Also, you have received in your confirmation email when you signed up, there's some downloadable content there, including a downloadable school packet at nationalceliac.org/school and our back to school webinar at nationalceliac.org/BTS. That was a lot to say. So at this time, I am proud to introduce our experts for today's events, Andrew Rosinski and David John Hommel. Andrew Rosinski is a law partner and the co-director of the Eisenberg and Baum Law Center for Deaf and Hard of Hearing. He has a strong national presence with admissions to over 40 federal district and appellate courts spanning across more than 25 states. In his impactful career, he's obtained over 25 favorable verdicts from juries, judges, and arbitrators. Andrew has argued dozens of cases in appellate and trial courts throughout the country, including the United States Supreme Court. And David John Hummel is also a law partner. He runs the disability rights practice at Eisenberg and Baum. When he was promoted to partner, the firm described him as a strategic advocate and an architect of hope, building bridges to access and equity for those who have been long marginalized. So both of these gentlemen are people who we are very happy to welcome back to this webinar series. So Andrew and David John, welcome again to Ask the Experts Live.
Thank you so much, Chris, and thank you so much for having us. Very happy here and excited to be presenting on this topic. Beyond the 504 plan, navigating disability accommodations in education. I want to go into what our objectives are for this webinar so that you can understand where we're going to be touching here today. And what we're going to go into is understanding your legal rights. A lot of times people don't necessarily know for sure or that have been told by others what their legal rights are that may not be accurate. So we want to clear up any misconceptions, anything that you may have been told that may not be 100% accurate, so that you can come in prepared with the tools that you need to assert those rights. We're also going to be applying and talking about some game-changing Supreme Court decisions that have happened in the last 2 years in the K through 12 and collegiate space. So, and how those have a dramatic impact on what is available to you now when you advocate for your rights. So we're going to be touching on those as well. We're also going to be telling you how you can navigate the accommodation process, what you can do strategically to make sure that your rights are protected and that you can assert those rights effectively. And that includes, documenting and escalating those types of issues. And then lastly, we're just going to go over how to solve real world problems that people face regularly on an everyday basis, and help you navigate through those. And then at the end, we're going to go through that question and answer so that we can answer any of those looming questions that you may have after hearing the presentation. So that's a little bit about what we're going to be doing and what the objectives are. So with that, I'm going to turn over to David John.
Hi, everyone. I want to echo Andrew and thank you all for being here. I want to thank Chris, Carla, Kim, and Stacy for welcoming us back. What I can tell you about this presentation is, as with all my presentations, I demoed it before my 3-year-old daughter, and she said it was better than Paw Patrol. Did I bribe her with a nice pot beforehand? I certainly did. I don't know why that's relevant, but I think either way, we'll have a very informative hour for you, and certainly Andrew and I are at your disposal after this presentation is done, especially if your questions aren't answered. So turning into the backdrop of today, celiac disease. So under federal law that is within the United States, celiac disease qualifies as a disability. As Andrew will talk about in just a moment, under the Americans with Disabilities Act, which applies to public accommodations, and Section 504 of the Rehabilitation Act, which applies to entities that receive federal funding, such as private schools. Disability is defined as any physical or mental impairment that substantially limits one or more major life activities. That could be eating, as an example, or if it affects a major bodily function, and that could be the digestive system, as an example. Federal law requires reasonable accommodations to accommodate those with disabilities. So that would include students with celiac disease. And courts have said that students are afforded a like experience. Now, what does a like experience mean? What courts have said is that public accommodations, schools, private schools, they should consider how they treat non-disabled individuals and make sure individuals with disabilities receive a similar or substantially similar experience. As an example, imagine you have a child who not only has celiac disease, but is in a wheelchair. They want to go to the movie theater to see Fantastic Four. They would be entitled not only to a seat restricted to the front row, but they could have a seat in a different part of the movie theater, and they could have a seat next to a family member or friend, because that's what the expectation is for individuals who are not in a wheelchair. In addition, when it comes to reasonable accommodations, these accommodations could pose additional costs or burdens on the school or any other covered entity. For example, outside the school context, imagine if there's an apartment building that has a fee if you have a pet. Well, if you have a service animal, that's not a pet. So there should be a waiver of any of those fees. Likewise, imagine if there are apartments with and without wheelchair access, and the ones without wheelchair access are more inexpensive. The person should not be relegated to the more expensive units simply because those are the only ones that provide accommodations. So that's what that means. Really, globally as a whole, when it comes to accommodations, one of the fact-intensive enterprises is reasonableness. What is reasonable under the circumstances is on a case-by-case basis. For example, Andrew runs the Deaf Law Center. Imagine a child who is deaf. They were to go to a pediatrician or go to a hospital. Asking for an American Sign Language interpreter as a reasonable accommodation would often be reasonable because that is the person's primary language, and that's how they're able to effectively communicate with the pediatrician or hospital staff. Now, on the other end, imagine if that same child requested an American Sign Language interpreter 24/7, or maybe an American Sign Language interpreter, not just an interpreter, but a doctor or nurse who is fluent in ASL. That could be on the other end of the spectrum, and based on the circumstances, that could be considered unreasonable. And finally, another important inquiry in this entire discussion is whether something arises to a fundamental alteration. Now, what does that mean? As the name implies, that's something that dramatically changes an essential aspect of a covered entity's program. So again, stepping outside the school, Let's think of a planetarium. Imagine you had a child with low vision. They went to the planetarium and you asked the owner of the planetarium, could you turn the lights up? My child is not able to see everything that's on the ceiling. Well, the owner may very likely say we can't do that because that's part of the experience of the planetarium, and that would affect other paying customers that we have. So throughout this analysis, we look at reasonableness, we look at necessity, which is the like experience, and we look at fundamental alteration. But let's take a step back with Andrew to talk about some of the laws that we frequently consider.
Thank you, David John. So typically in the K through 12 and also in the college space, there's three laws that are often dealt with. You have the ADA, you have 504, and in the K through 12 space, the IDEA. So the ADA, Title II affects public schools. It covers all government entities that are involved, that is public schools. It also, Title III would cover private schools. So both private and public schools are covered by the ADA. And so those entities do need to provide reasonable accommodations to ensure equal access in this space. And going on to Section 504, all federal funding recipients have to follow the requirements of Section 504. And again, it's very similar to Title II of the ADA, providing equal access, providing that like experience that David John was talking about, to ensure that they get that similar experience that the non-disabled students get. And then there's the IDEA, which oftentimes in a lot of K through 12 settings is used as sort of a shield to not provide certain types of accommodations. A lot of times with the IDEA, which deals with ensuring you have an individualized education plan for students with disabilities, they say, well, eating is not, part of your IEP, so we don't have to, accommodate your dietary restrictions because that's not really part of your education. And they use that as a sort of shield, as a way to not have to accommodate you in that space. But that is wrong. And there have been, luckily, two really big Supreme Court decisions, which we're going to be going over next, that explain that. And so with that being said, I want to go to the first Supreme Court decision that I'm going to be going over, which is the Perez case. And so once it gets up on the screen there. So while that's going on, I'm going to talk about the Perez case. So the Perez case happened at the U.S. Supreme Court in 2023, and it's the Perez v. Sturgis case. And essentially, what happened there, there was a deaf student who was trying to sue under the ADA, ADA and the Rehab Act, for damages because the school did not provide him with sign language interpreters during his school, and that really affected his ability to learn and understand, and that's going to affect the rest of his life because of their failure to do that. The school argued that that should be covered under the IDEA, and that there should be no private right of action to sue under the ADA and the Rehab Act. And in that case, the court rejected that. And in a 9-0 decision, found in favor of Mr. Perez and said that you can pursue claims for compensatory damages without first exhausting the procedures outlined in the IDEA. So this decision really provides students a direct path to go to federal court for monetary damages without having to go through the onerous process of the IDEA administrative exhaustion proceedings. And for anyone that's had to go through that, you know that is a very long and often tedious process. So this is a huge decision that allows for direct access to assert your rights and to get damages for that. And we're going to go to the next case, which is the AJT case, in which this just came out in June. And this was another one of those student cases where someone was bringing a lawsuit against their school for failing to accommodate. And the court actually overturned a pretty bad, line of precedent, which basically said that for you to prevail in the education space, you have to show that the school acted with bad faith or gross misjudgment, which the court resoundingly rejected, and basically said that the same standards that apply everywhere else in all other areas of the law apply here, that you just have to show that you were treated differently on the basis of your disability. You don't have to show bad faith or gross misjudgment to get damages. You just would have to show that they were deliberately indifferent to your rights. And so with these two decisions, Supreme Court decisions together, it provides a really great precedent and framework for people to be on solid ground for asserting their rights in this space. So let's go to the next slide. So
before we get to examples in the K through 12 context, in the college context, let's set a few ground rules in terms of where we come from in terms of our evaluation of case law and generally what's required. So looking at the left-hand side, no expert testimony required. This is an often important consideration, really barring a contemporaneous doctor visit or a doctor on site, or even the successful scanning of something like a NEMA sensor. There's really no way to link the fact that a student at a middle school, high school, or college consumed food with gluten. So it's important to know that you don't need to have an expert conclude that to a degree of scientific certainty. I think if you're able to establish that, look, let's say in college, I went to the dining hall, I had nothing in my stomach, it was breakfast, I ordered food, I consumed the food. Within 2 to 3 hours, I experienced my hallmark symptoms of a gluten poisoning. And, with that, I developed, short-term and long-term issues, things of that nature. That could be enough. Again, it's a very lawyerly throat clearing to say, but a lot of the stuff is on a case-by-case basis. But with cases that we've looked at, that generally is accepted, that there's no requirement to have a doctor or some other type of medical evaluation to conclusively determine that you've consumed food contaminated with gluten. In the middle, this part is crucial. Document, document, document. I'm reminded of a quote from the movie Memento by Christopher Nolan, in which I was preparing for the presentation. The main character says, memory can change the shape of a room, it can change the color of a car, and memories can be distorted. They're just an interpretation, they're not a record, and they're irrelevant if you have the facts. So from my world and Andrew's world of being in court, we always look at cases where about a year or a year and a half in, and we think about in hindsight of like, oh man, we really wish our plaintiff would have documented so-and-so, a conversation with so-and-so or such and such document. So what we recommend is certainly when you make requests for accommodations, have a document in which you can turn to, be it an email, a written letter, in which you've offered a clear request for accommodations. You can identify why you need accommodations to accommodate celiac disease, what those requested accommodations are. Then ideally you would receive a clear denial or a clear response from the school in any type of capacity. Certainly, the more documents you have, the better. I know it's easy to say within the confines of a webinar, and if you keep sending emails and letters, that may shoot up the antennas of the school to say, is this family considering legal action? But if you do have to unfortunately resort to legal action or even go to a governmental agency to lodge a complaint, the more evidence you have to show, look, we've made clear requests for accommodations over the course of several weeks and months. They haven't been implemented. Here's what the school has said. We've given a medical letter reinforcing that we have a celiac disease diagnosis, or symptoms consistent with celiac disease, and that will help you in the long run. Building off from that, on the third column, case support, court decisions like JD versus Colonial Williamsburg. This is a case in federal court. In federal court, for the quick synopsis, there's the trial courts. Those are federal district courts. Then there are circuit courts. They're responsible for clusters of district courts in multiple states. Then all those circuit courts get appealed to the Supreme Court. So the JD case is in a court known as the Fourth Circuit. It's responsible for a few states, but it is, as far as Andrew and I can tell, it's really the only decision that has directly confronted some of these issues head on in terms of celiac disease. In a nutshell, in this case, a young boy was going on a school field trip to, as you can guess from the defendant in the case, Colonial Williamsburg, had a very, old-timey vibe. That's part of the experience baked in. He's had prior issues with being glutened at restaurants, even restaurants other than this particular tavern. It's one that he hasn't been to before. So, as a reasonable accommodation, he and his father had asked whether the boy JD could bring his own meal in to eat with his classmates. And the tavern said no. The trial court ruled against the family and said that the accommodation was not necessary. That was appealed to that federal appellate court. And the federal appellate court said, no, we think this is worthy of a jury's attention, that they should consider whether or not this is necessary. And what's important to underscore about that case is the tavern's head chef, and this is recounted in the court opinion, the tavern's head chef had extensive training as a chef, including one-on-one training specifically focused on gluten-free meal preparation. Over a 5-year span, the head chef had prepared roughly 4 to 5 gluten-free meals a day for a total of over 5,000 meals without ever receiving a single complaint that the meals actually contained gluten. In addition, the head chef apparently knew how to use a separate designated area to prepare the meal. He knew how to sanitize the area and the utensils beforehand. He knew to use a fresh set of gloves and apron and knew to use a separate oven. Now, those facts were recounted by the dissenting opinion in the case. Appellate courts at the federal appellate level, besides the Supreme Court, are 3 judges, and this was a 2-to-1 decision. So the dissent really recounted those facts, but for the majority, which is the 2 other judges, they disagreed. And really the important fact was JD had went to other restaurants, was gluten there, giving him reasonable concern that even if this place had purported to have good policies, good protocols with the staff and the chef, that he still had a realistic concern that they would make a mistake and cause those short-term and long-term consequences. So this is a very important case for our practice. When Andrew and I litigate cases, we point to this simply because it shows that you don't even need to have prior issues with the school itself. You just need to have prior issues in general in which you have a reasonable deterrence to consume the food at the school. In building off the JD case and a few other scattered court decisions throughout the country, the Department of Justice had issued settlement agreements that are public with 2 universities. You see at the bottom here, there's the Lesley University. Then the Rider University followed suit, in which it built off the Lesley agreement and expanded it to allow students to pre-order meals. Essentially, looking at these settlement agreements collectively, the universities had agreed to provide nutritionally comparable gluten-free and allergen-free meals, individualized meal plans for students with dietary restrictions, reasonable steps to prevent cross-contact, and enforced mandatory and regular training for food service staff. Now, again, this is not legally binding on other universities. It's certainly not legally binding on other middle schools and high schools. Likewise, the JD case, outside the confines of the states in those federal courts, that would not be binding elsewhere. But these do provide important benchmarks in terms of what's required, what the Department of Justice expects to happen, and the JD case being really the first to issue pronouncements on what's acceptable. That is really something that other courts would look to and follow suit with. Now, with that, let me pass the baton to Andrew. As I stepped on his lines beforehand, let me make sure I give him over. So he's going to talk to you a little bit about common K-12 scenarios and solutions.
Thank you so much, David John. We wanted to go over some scenarios that people may have seen in their experiences. A common scenario that we often see in the K-12 space is that you have to give advance notice of so birthday celebrations or things like that. But the teachers or the cafeteria does not follow through with accommodating those requests for gluten-free meals or gluten-free birthday celebrations or things like that. And there's no need per se that you should be required to have to give 2 weeks or 3 weeks notice. If you put the school on notice that your child needs gluten-free meals, or ensure that if there are celebrations in which food is going to be provided by the school, that there are gluten-free equivalents provided, they have to provide that. They have to provide that like experience. And that doesn't mean that everyone gets pizza and you get iceberg lettuce salad with a tomato on it, and that's all you get. That's not a like experience. It's providing a reasonable equivalent, and so providing that. A lot of schools will try to say like, oh, well, we can give you this one option, or we can't accommodate you at all. But just know that you do have a right. And if you encounter that problem, make sure that you document, that you escalate it. You can even show some of the DOJ settlements that David John just referenced. Those show sort of a benchmark of what institutions are required under ADA and Rehab Act and whatnot, so they can so it's not just take your word for it. This is what the federal government has also agreed is required and reasonable under the law. The next scenario is just saying, well, celiac disease is not a disability, or we don't have to accommodate you because it doesn't apply. Some of you may have heard that before. The law is pretty clear, and it does show that celiac disease is a disability, and you can certainly show that J.D. Colonial Williamsburg case, which very clearly explains that. And to the extent that they still don't listen, obviously document it and then escalate it to filing administrative complaints with the DOJ, or contacting an attorney. Last scenario that we see is, they say that we just can't accommodate gluten-free food because we just don't have the space in our kitchen to accommodate. And nowadays, there's been so many developments on how to prepare and provide gluten-free food safely, that can be done in such tiny and small areas that it's just not much of a credible argument anymore. And to the extent that they just don't know how to do it, there are companies out there like Menu Trinfo and things like that that schools can consult with to provide them the tools that they need to get it set up at their school and get it done safely. So the fact that they say this might be a fundamental alteration or undue burden is just most of the time not credible. And let's move it on to the college arena. Deja.
Thank you, Andrew. So as we have here, we have a few different, cells here, raising in line with questions that we've received. Taking each of them in turn, you have the private dorm issue. Student housing includes a mandatory meal plan, but the student claims that they can't provide safe gluten-free meals. Then in the next cell, the meals are insufficient, nutritional issues, academic issues in terms of after glutening, the student is unable to have a makeup exam, the dining hall restrictions in terms of the number of options, and then finally, whether or not the student can bring other appliances such as a microwave or a mini fridge into their dorm room. Again, globally, I would lodge requests for as many things as possible and see what the school's response is. And I would do this as early as possible. You know, if you're about to apply to apply to college, I'm thinking ahead to law school. If you apply to college and once you're accepted, start lodging those requests. See if you can get any information. Maybe you can meet with the head chef of the different dining facilities or whoever's responsible for planning the different meals and foods that are used. Do you have policies on gluten-free food? Do you have policies on gluten-free training? If those things appear to be problematic, especially if your child, if the student has issues with gluten in the past, you can request an exemption from the student dining plan. Again, as we've said before, document, document, document. If you have a medical note in which you say that my child has celiac disease, these are the consequences of consuming gluten. And before that reason, we would request reasonable accommodations, such as a meal plan exemption. For example, in one of those DOJ settlements, in the Rider University settlement, it even specifically said in certain instances, Rider does not readily offer exemptions from its meal plans for students seeking exemption due to a food allergy or food-related disability. So in addition, addressing some of these concerns, it's very reasonable to make a request for a wide range of safe, nutritionally comparable, gluten-free options. And by having that, you also necessarily require a reliable menu and food labels. Oftentimes, we've seen this at restaurants, at buffets, or even at any other type of setting where things are labeled as gluten-free, but that label might not be trusted for a variety of reasons. Does the kitchen at this place have reasonable precautions in place to avoid cross contact? In addition, as expected, you can make a reasonable request for mandatory and regular training on celiac disease and gluten-related issues with associated policies and procedures for food service staff. In addition, you could request the preparation of these gluten-free options in a gluten-free kitchen with adequately trained staff. As Andrew said, with companies like Menu Trinfo, it's our understanding you can make a certified gluten-free space on a picnic table. Doesn't mean that a college university needs to expand its kitchen, dramatically alter its kitchen. And these are things that you could flag in advance. And certainly, too, I think the most you could do is have ongoing conversations with the school, be it the kitchen staff or the school administrators at large, because I imagine these days most schools have a policy in place. But the frequent issue is whether or not that policy is actually effectively implemented. As we know, gluten lurks in a variety of different products, from soy sauces to soups. So it's not just a matter of the staff understand that they need to handle food with or without gluten. They need to understand the ramifications of the ingredients they use and the different choices they make. So, kind of summing up the action steps for families, as we've touched on, document everything, clear requests, clear response from the schools, be it denial or something else. Maintain different documentation in terms of the impact glutenings have on your child. So these are things that you could always have for future litigation or grievances. As you are going through the conversation with the school, keep a dedicated folder, either physical or electronic, on your computer. Store this information in the off chance that you would need this in the future. As Andrew had flagged, and as we discussed about before, you have the DOJ settlements, you have the JD versus Colonial Williamsburg case. You even have the text of these federal statutes, the Americans with Disabilities Act, or Section 504 of the Rehab Act. In addition, we didn't talk about this, but in college dorms, you could also consider the Fair Housing Act. So you have these laws, you can show the school administrators these laws, these settlements, these court cases, and say, look, I mean, my child has celiac disease. My child requires reasonable accommodations. Could you explain to me why the accommodation requested is unreasonable? You can memorialize that within a written document from the school, so you have that necessary if you have to pursue litigation going forward. Let me turn it over to Andrew to kind of sum us up today on the key takeaways before we get to the Q&A session.
Thank you. So what we want you to walk away with all of this is, number one, celiac disease is a recognized disability under the law, and it requires accommodations. Courts have firmly established this, and if anyone tells you otherwise, they're wrong. Next is, you have two really strong Supreme Court cases behind your wings now. that support, that you don't have to, that the schools can't hide behind, administrative exhaustion procedures or IDEA, processes to block you from getting those accommodations. You have the right to be treated equally and get a like experience just like everybody else. And so, again, if you're being told by administrators or schools that that's not the case, then they're wrong. Next is documentation is your most powerful tool. Make sure that you document and you document well, put things in writing, send letters, emails. If you have phone calls, send confirmatory, emails of those phone calls so that everything is in writing. Next is that you can seek damages if you have to pay, out-of-pocket costs for, doing all these extra things because they won't accommodate you, or that, you get glutened and you incur medical expenses and things like that. You can recover all those damages. And then lastly, that you don't have to show that they acted in bad faith. A lot of times when people deny accommodations, it's not because they're trying to do so in bad faith. Sometimes it is, but a lot of times is that they're just not educated about what the requirements are, or they have a strong belief that the law is something that it may be not. And so just know that if they are not treating you or your child in an equal manner, or providing the same types of benefits and privileges that all the other students get, that there could be a problem here. So those are the key takeaways here. We want to get to your questions because oftentimes the questions are the most important, because we want to see what lingering things people have after getting all this information. So with that being said, thank you so much. Really appreciate your time and listening to us. And let's get to the Q&A.
Yeah, Andrew, David, John, thank you so much. We have received in a lot of questions, and a lot of people kind of that same underlying, what you just discussed and what can we do in these scenarios. But it's interesting to see how many different situations occur with people all across the United States. And in some cases they're bringing attention to this. Other times, I know with my son who went through, we had no problem with our schools going through this. So it's not we're not saying all schools are like this, obviously, but there are situations that pop up, and everyone on here who's asking these questions just have that concern about their kiddo in mind, and they want to have we just want our kids to go through and have an experience just like any other kid. We don't want them to be, tied down or stigmatized in terms of because of they have to follow a gluten-free diet. So I have a question about what you just said like 5 minutes ago, Andrew. You're talking about they're wrong, and you can tell them that they're wrong. How about those people who they don't want this to hang over their kid throughout their educational career? They don't want to speak up, but they know it's not right. Is there any advice to them? I mean, they may be shy and I want to say it, you're wrong, but is there anything? I know they want to stand up for their kid too. So how do they handle that tricky situation?
Well, you don't always have to come into it in an adversarial posture. A lot of times you can, start off, and I highly recommend this, trying to work in a collaborative way, educating them about celiac disease, letting them know the challenges that your child faces, and letting them know of the impact of how them not being accommodated has on your child and your family, and really laying it out in a very clear way. Oftentimes is the best way to start it off. And it's super important to do that first. You don't want to go into an adversarial posture. So that's what I recommend doing first. Hopefully, maybe 30 or 40 or 50% of the time that works and you don't have to go further. But it's an interactive process. You go back and forth. They may need to be educated on things. They may tell you about their restrictions that they feel like they have. and you try to work with them and go from there.
No, I think that's good advice. I think sometimes we get a little bit too adversarial when we go into these situations. So it's always good to try to do that kind of compromise type of thing and have a cordial kind of conversation about it if possible. So we did have a question come in, and I think it goes back to proving your case. And when we talked about that, somebody had indicated that they are having to buy materials for their child at school because if there's a party or something like that, the school will buy like Play-Doh and adhesive and anything else for any other child, but they'll make this parent buy the gluten-free ones because it's only affecting her child. And she's wondering what does she reference to let them know what they're supposed to do? Does this go back to like that JD versus Colonial Williamsburg and also the DOJ settlements? DOJ settlements, is that something that she should reference back to in that case?
Yeah, David, John, you want to take that?
Of course, yes, absolutely. I think the underscore we want to make is that the school can impose a surcharge for parents and students who have celiac disease. So for example, in seeing other questions, if there's other students with peanut allergies and those students are accommodated, we want that like experience. We want our child to be treated just as everyone else. We want them to be able to have art time. We want them to be able to have the parties and be able to participate. They don't want to kind of be siloed off separately just to avoid any type of cross contact. There's not accommodations for them. That could be food, that could be the art supplies. So I think what's important is to fan out that look, there are these federal statutes, there are these DOJ settlements, as you said, Chris. There's cases out there in which students receive the same type of treatment as anyone else. And it's the school's burden to show, as Andrew had spoken about before, that there's some undue burden. And I can't imagine the school can't fork over some cash to buy different types of food products and art supplies, or they have to show a fundamental alteration, which I gave that planetarium example. I can't think of many examples in the school in which it would fundamentally alter their services. So I think it's important to put the school and hold them accountable. Certainly not be adversarial. We want to advocate for our kids, but we want to try to strike a collegial tone at first, just because oftentimes I think a lot of these issues are not the bad faith that Andrew spoke about, and it is more of the benign neglect and apathetic attitudes that they just don't know. Certainly they should know, but they just don't know. So we want to try to gently educate them and say, hey, just want to be aware that there's laws out there that focus on this stuff.
Yeah, and that kind of segues nice into another question that we got where there's a repeat situation happening and there's a lapse of judgment, but they admit, oh yeah, we made a mistake, but it's happened many times. So you talked about effective implementation of process. Obviously this isn't something that is, there's a process in place but they're not following it. At what point does this become a legal case or something that there should be legal action taken on, since they are acknowledging that it's something that they have a protocol in place? Oh, we messed up, we didn't do it, but it keeps getting repetitive. When should that be elevated up to a legal type of situation?
I I think that obviously things happen in life, and there can be honest situations that happen. Obviously, I never recommend if someone makes one relatively minor mistake that you should run to the courthouse for that. But yeah, if it's a repeated issue and it happens over and over again, I would just sort of you know ask for why did this happen, what needs to be put in place in the future to make sure this doesn't happen again, and ask those specific questions in writing to them, and then hold them to account. If they say, okay, we're going to be doing this moving forward to make sure that this doesn't happen again, and they don't do that again, then certainly you can call them out on it. So it's I think being very clear with them and asking them what they're going to be doing next time to make sure this doesn't happen is super important. And then obviously if it keeps on happening after that, then I think you should explore potential next steps.
Okay. Okay. I
And
do
I
want to
think
touch.
just to
Oh, I'm
add,
sorry.
sorry about that, Chris. I think just
No.
to add, especially in looking at the question and the school and or sorry, the daycare is professing that they're still learning and doing the best they can. I mean, it's one of those things where could you imagine in another setting, you step aboard an airplane and the pilot goes, "Hey, everybody, I'm still learning. I'm going to do the best I can on this flight." Doesn't really inspire a lot of confidence. And I think, too, given a lot of misconceptions around celiac disease and the effect of consuming gluten, I mean, certainly I think schools understand more readily, let's say a peanut allergy, or maybe even, let's say, a college university, a shellfish allergy, where really a one-time mistake that could be fatal. And I think that schools need to understand that sometimes a one-time accident or a one-time misjudgment could have long-term and even short-term ramifications. So there is no magic marker in terms of there's this one accidental encounter, whether or not you should file a lawsuit, but certainly after repeated episodes, I mean, I think Andrew and I would always counsel you should consider legal advice about whether to pursue a case, just because once it kind of blossoms into multiple episodes, that seems to show that there's some type of reoccurring pattern of poor training or poor judgment.
Okay. So I want to kind of tangent off this because we got a lot of questions in during the registration process for this webinar around healthcare plans versus 504s. And there are situations specifically where somebody had said we had a 504 meeting, we were denied at the 504 meeting because they said we could have a health plan in place instead. Another person asked, is a health plan as good as a 504 for accommodations? From a legal standpoint, what are the health plan versus 504 argument that is brought on by schools or these meetings, what can individuals and parents do to kind of show, no, a 504 is what is necessary in these situations?
Yeah, I think sometimes administrators might get caught up in their terminology of what this needs to be classified under, or what rules or requirements need to go under this plan or that plan. But I think in terms of what the law requires is equal access, like experience, and all of that. So basically saying, this is what we need. This is what my child needs to be able to participate and enjoy things in the same manner as the other children do. And this is why what we're doing right now doesn't do that. And I feel like that is sort of, when you're reframing it in that way, and the law says that my child can't be discriminated against based on their disability, treated differently based on their disability, which clearly in that situation or this situation they are. Then it's not about whether it's under this health plan, whether it's in the education plan, or whether it's this. It's whether they're going to provide that equal access or not. And so framing it in that way may be better because I do know that there are a lot of rigid processes and plans and things in place in the school system. And a lot of times administrators see that as like, we cannot go outside the bounds of what is, under these two things. But I think reframing it in that way, it hopefully would, at least give you the tools to say, we shouldn't be just bound by this particular framework of that or this, but just making sure that they're not treated differently because of their celiac disease.
So we've had a few questions come in. I mean, these are kind of offshoots of a lot of things we've talked about already. But there are some specifics I want to touch on. I know you talked about public schools versus private schools, and somebody asked a question in regards to their child's continuously left out, because even though they have a plan in place, the private school, doesn't consider it a document. But do they have any rights as parents, and does their child have any rights, knowing that they have this document in place, but the private school itself is not still accommodating?
Yeah, a lot of times, schools will say to people that have students in private schools, "We're a private school. We're not bound by what these public schools, have to do, and we don't have to do anything." A lot of private schools, surprisingly, do receive federal funds. Actually, during the COVID pandemic, uh, uh, there was a huge influx of private schools taking the PPP money and the EDIL money, which subjected them to the Rehab Act during those time periods. But even if they're not subject to the federal funding, Title III of the ADA allows you to get relief for private schools and allows you to get that equal access under Title III. A lot of parents don't know that because it oftentimes is they're misinformed by the school about what the requirements are, and so it's really important for people to know that they have that law on their side. And also, there in a lot of states, there are a lot of good state laws that can be used to supplement the ADA as well. So you do have protections, and you should, even with your private school, assert the same kind of rights in the same manner as we've been talking about in the other situations.
Okay. There's a few questions. I know we have about 10 minutes left, and I know there's a few questions centered around college that I wanted to touch on, and this one kind of leads up to it. And the daughter is a junior in high school. They're asking about pursuing a 504 now. Is it necessary to do it now to get the accommodations in college? She's not concerned about accommodations in high school, but she knows it's going to be an issue home away when the child goes to college. So is it something they should implement now at this point in time so that there's a history of them having the plan? Or is there anything, if they get it the year before they go to college, is there a better path for that?
Any sort of documented history of the use and necessity of accommodation is always something that is helpful, but it's not required. So even if someone never had a 504 plan, or they can still provide obviously the medical documentation that they need to prove that they have celiac disease, and request the accommodations that they need to be able to participate. That requirement stands whether you had one in K through 12 or not. So yes, it's always helpful to have a history, to the extent that they challenge it to say that, oh, this is not necessary, or this is completely unreasonable. If a similarly situated entity has been able to implement this and it's been fine and not been an undue burden or a fundamental alteration, it goes to the reasonableness argument. But in terms of what is required, there's no such requirement. But certainly if there is pushback, it's always good to have that kind of history or previous situation you had where it was successfully implemented.
So now I have two questions, one on each side of a meal plan, if it's mandatory or if it's not mandatory. And so the one question is, what's the best way that you can initially approach a prospective college about opting out of a mandatory meal plan due to celiac disease? Is there any precedent that they can speak of when talking to this?
David John?
Thanks, Andrew. I think in line with what Andrew has said in the past couple responses is a lot of this is we want to make sure the substance is there and the form doesn't really matter as much. In talking about an individualized health plan, showing that to a college or a 504 plan in the past, or any type of medical documentation. I think as early as possible, it's important to convey to the school, my incoming freshman has celiac disease. Could we have a discussion about what your meal plan looks like? What are your gluten-free options? How many dining facilities do you have? What are the gluten-free options there? I'm sure at many universities they have one or two gluten-free options, but is that enough to have a nutritionally satisfied freshman? A lot of these options, of course, are low protein, high in sodium. And maybe for students without celiac disease, they're able to have a wide array of options of breakfast choices, whereas it would be the same repetitive meal over and over again. I think all of these considerations should be patched together and say, look, communal dining is one of the cornerstones of the college experience. That's where college students go in between, before and after classes, to strike a bond, to have conversations, to even study there. So it's important that they're a part of that experience. Now, we would hope that the college would make accommodations, increase the gluten-free offerings. There's no guarantee, and if there's not that guarantee, then I think the option for the colleges is to remove the mandatory meal plan, or at least consider some type of modification where it would satisfy the student. So I think the more information you could provide, the better, and make sure that the college is aware of that the student has celiac disease, the consequences of consuming gluten, then really put the burden on the college to give any information they have to explain why they think the meal plan would be satisfactory.
Okay. So that kind of leads into that second part of that question where we have somebody whose kids off to college, they notice that it's a small food court. There's not a lot of options there, not any options there actually, but she's not forced to be on that meal plan. So in that case, would she just simply provide that request to have gluten-free options, much like she would at a restaurant when they approach a restaurant in that situation?
Yes, absolutely.
Okay.
And I think the restaurant analogy is certainly apt just because another great part of being a college student is when you go to the dining facilities, you should have the option to be spontaneous. I'm
Mhm.
in the mood for tacos today. I'm in the mood for a cheeseburger today. I'm in the mood for a soup or a salad. So I think you want to have clear indicators of notice to the college in different capacities. You want to go as high up on the chain as possible to make sure that they can say later on, well, you spoke to so and so, but if you would have flagged this and ran it up even higher, we would have accommodated you. Make sure you send it to as many email addresses as you can, of course, without being, as we said before, coming across as adversarial, to make sure that the college is aware of what the students' concerns are and to make sure that they have as like of an experience as other students. So in that case, you do that now because certainly it's not any college student's dream to be mired in the threat of federal litigation or to really have these issues kind of go on because we've seen in many types of situations where it's a snail's pace back and forth between the college and the student's family. So to the extent you can engage in maybe some of those uncomfortable conversations leading up to the start of freshman year, the better, so that hopefully then on the first day of school the plan is in place and you're able to consume as many food options as possible.
Okay. Okay. One more question, and then we'll let you go and have your time. This is kind of a follow-up on the talk around the IFP and the 504. The parents are wondering, should they push for that 504 since it's legally binding, or is it okay to just stick with an IHP if the school is making the accommodations?
It's interesting about a 504 plan, whether that's legally binding or not. From a lawyer's perspective, a 504 plan is sort of the culmination of a interactive process between the school and the parents and the kid, where they actually agree on what is necessary and required and outlines that plan. But from a legal standpoint, at least under the Rehabilitation Act, such form, having such form, or not having such form, but having that interactive process be in a series of letters or emails back and forth between the parties, and agreements being made and not being made, it doesn't change what the requirements are. The requirements are that they not be treated differently than other students, and that unless it's an undue burden or fundamental alteration, that they get equivalent options, and that be typically paid for by the school. And so, I just want people to not necessarily get so bogged down in the form over the substance. And the substance is more sort of make sure that your requests are clear, make sure that the expectations are clear. And obviously, a 504 plan is a great way to do that. But don't think that that's the only thing that's required, or that if you don't do it that way, that somehow your rights are any lessened.
Now, you had just indicated that it wasn't a legally binding document, but is that something that is seen in a higher regard if that 504 is in place?
I think I think it is, because it's a sort of it's a document where essentially everyone has signed off on and is agrees is you know what is required and is what the expectations are. So I do think that it's good to have for sure, because in other forms you may risk having that sort of certainty and agreement in one place. So certainly having that plan and having that plan to your satisfaction is better than not having that plan, for sure, in my opinion.
Okay. Well, Andrew, David, John, thank you so much again for taking time out of your busy schedules to answer these questions from our community, but also for everything that you do and the work and dedication you have for people with disabilities. So we thank you again for being on with us, and for everybody else who is out there and who has tuned in. Thank you for doing so. I do want to share we do have a couple of upcoming events. We have conversations on a monthly basis in our virtual support group called Living Gluten Free. It takes place on next Tuesday, the 12th at 7 p.m. This, like I said, is a monthly NCA hosted event where people can have an open conversation about gluten-free living. So there's often a lot of support and questions and people who've gone through same scenarios. So that's a great place to turn to for that community support. And then we're having a cook along. We're going to go ahead and in a few weeks, and we're going to do a class where you can join in. We're going to make some sheet pan dinners and a dessert that your whole family can enjoy. It's going to be a really a fun event. So that's coming up on the 27th. And you can go to our events page on our NCA site, and that will provide you with links to both of those and how you can register and log in. So again, a final thank you to all of those who attended and participated today. Please continue to visit the NCA website and our social media accounts for updates and announcements about future Ask the Expert live webinars and upcoming community events. So for Andrew, David, John, myself, the entire team here at the National Celiac Association, we thank you for joining us today. Have a wonderful remainder of your Wednesday.